Hi friends, a lot of people have been asking my observation on latest judgment of Supreme Court in Shanti Kiran. I think Shanti Kiran judgment of Supreme Court reaffirming the judgment of Delhi High Court in Quest Marketing and Shanti Kiran has finally, in my personal view, settled the issue against the revenue who have been labeling all kind of allegations, sometimes very stupid allegations, and correlating he has not filed returns, he has not filed 2-1, he is not appearing in 2B, etc., etc. Now the issue is settled that input tax credit cannot be denied if the ITC recipient has a valid tax invoice. On the date of advice, the suppliers were registered and there is no allegation of collusion or fraud. Now the revenue can take this collusion and fraud case and issue some stupid notices, but then we should answer in the show cause notice that there is no such thing, fraud or collusion. I don't think the revenue will now will be able to resort to these kind of stupid comments. Now in my view, Shanti Kiran judgment also in a way differs with the judgment of Ecom Gill. In Ecom Gill did not accept the judge did not accept the judgment of Quest Marketing on the ground that section 155, which was equivalent to section 70 of Karnataka VAT Act, was not considered. But in this judgment, the Quest Marketing has been approved. That is, there is no question of resorting to 155 that you have to prove the claim of your input tax credit. Therefore, the Shanti Kiran judgment travels far beyond Ecom Gill judgment in my view. And it also says that ITC simply is not a discretionary concession as we all have been claiming, but this is a statutory entitlement of the buyer. That is, the statute gives him a right to claim input tax credit if the transactions were bona fide and other requirements of law are satisfied, and if there was no fraud or allegation. The Justice Mishra, who wrote for the bench in this Shanti Kiran judgment, they clearly said that the innocence of buyers should not be doubted on some flimsy grounds. And if the statutory requirements are fulfilled, input tax credit cannot be denied for bona fide transactions. And the courts made some beautiful observations that administrative efficiency or otherwise cannot overrule statutory jurisprudence and fairness, and therefore the trust between the government and the taxpayer must be upheld constitutionally, and they have held so. Though it is not a very long judgment, but the observations and the interpretation of law given is absolutely finally settling this issue of input tax credit, the issues that we all of us face. And in this, the court also observed that a bona fide buyer can take all KYCs or precautions at the time when he purchases the goods. The law does not put any burden upon him to do post-supply monitoring, post-sale monitoring of the seller, whether he is dead, whether he is run, whether he committed fraud, whether he has closed the shop, whether he has closed the godown, or whatever may happen with him. So it is the bona fides have to be proved at the time when goods are purchased. Post-sale inquiries, there is no onus cast upon the buyer to continue to trace the supplier. Therefore, this allegation which department generally levies, we went there, the shops were closed and shops were never happened, it would not make no sense at all. And the other observation made by the bench is that the interpretation has to serve the purpose of law, and the constitutional intendment and interpretation has to be based on a purposive interpretation. That is, the input tax credit, which is a statutory entitlement, must be given to the buyer and not denied on grounds which are extremely flimsy and which have no legs to stand. And the Court, by affirming the judgment of Quest Marketing of Delhi High Court and Shanti Kiran of Delhi High Court, now there is no doubt that all the show cause notices issued by revenue all over the country by whichever department, including DGI, under Section 74 would have no legs to stand. Now, the question being asked is, to me, by various youngsters is, does it overrule Ecom Gill? No, the judgment does not overrule Ecom Gill. Ecom Gill judgment still prevails that the transactions have to be bona fide. That is, you still have to prove the statutory requirements of Section 16(2)(c). There is no denying that the goods should be physically received. Ecom Gill was basically emphasizing the physical receipt of goods, and this judgment does not go away from this principle because it says all the statutory requirements must have been fulfilled by the buyer. The only thing, in my view, which it departs from Ecom Gill is that the onus under Section 155, which was the cornerstone of Ecom Gill judgment, has been done away with as the court has confirmed the ruling of Quest Marketing. And Quest Marketing, there was no such issue raised. But Ecom Gill and Shanti Kiran, they operate in the same field because entitlement of input tax credit. But here Supreme Court has gone further. It says the post-sale inquiries are not required to be done by the buyers. There is no onus cost upon them. And the other issue raised in this judgment is whether the input tax credit could be denied by simply levying an allegation of collusion or frauds. These allegations, there has to be a material evidence in the show cause notice that can, point out to a possible collusion between buyer and supplier. So we will have to see from fact to fact. Other question being asked to me is whether this judgment shall operate under Article 141 Constitution of India. My answer is yes. This judgment's authoritativeness cannot be denied simply on the ground that this was not passed under GST law, because GST is also a VAT law and the VAT law was also a VAT law. And this is more imperative in nature because here these RCs of the suppliers were cancelled retrospectively in Shanti Kiran and they did not deposit tax. Now these are the two major issues that we face in GST mechanism. Therefore, we must quote this judgment in all our replies that this operates under Article 141 and the revenue will have nothing in their mouth to speak that this judgment is not under GST law, therefore not binding. I think Article 141 completely binds them. In all our replies in show cause notices or in our appeals or in our arguments, we must very strongly contest Article 141. It's my final view that these judgments shall operate as an authority under Article 141. So friends, these are my observations on Shanti Kiran, a beautiful judgment, but it does not overrule Ecom Gill. Ecom Gill stands on its own. That is, the physical receipt of goods has to be proved. The only thing is the Ecom Gill did not agree with the Quest Marketing, and in Shanti Kiran they have endorsed the ratio of Quest Marketing. This is the only differentiating feature, but both judgments are applicable and we need to study the factual matrix of our own cases and apply these judgments accordingly. But this judgment, being a later judgment, has much more imperativeness and legal force for us to argue the cases in the courts or before the authorities. Thank you very much.